Good morning. A case how will has to be proved with the details, the relevant provisions, good judgment. I want to share with you. This is AR 2023 Supreme Court 4787. Beniram died through LR and other Shiv Singh versus Shiv Singh. This is Himachal Pradesh case. See, before that, you see what happened. Actually, Leelavadi died in the year 1987. Her husband predeceased her. Therefore, Leelavadi's brother claims that Leelavadi executed a will bequeathing the property in favor of the Sohan Lal. Leelavadi's husband, brother, son filed a suit challenging the will. So what had happened? The trial court decreed the suit and stating disbelieved the will. Then the first appeal, the appellate court believed the will, set aside the trial court judgment. Second appeal before the High Court set aside the appellate court judgment and confirmed the trial court judgment. And Supreme Court also clearly held that the second appeal, lower court judgments are good according to law. So the most important thing is Section 63C. Section 63C that when there are requirement of two witnesses, if one witness says he did not see the other witnesses signing the document, so they say this mandatory requirement of 63C not complied. Another thing is that the will was written on one date and registered on another date, but witnesses says that both are the same day. So something artificial evidence are not properly trained witnesses. Therefore, the Supreme Court has said once attesting witness denied execution of document while other witness did not establish the execution, neither document writer who scribed the will or anyone from registrar office was examined to prove its execution. Compliance with the essential legal requirement in terms of 68 and 71 of the Indian Succession Act, the will is not proved. Therefore, they say under Section 15 of the 1956 Act, Indian Succession Act, the legal was entitled and injunction was also granted in favor of the Leelavati's husband's brother's son. So this is what they say. So I would like to take you to what the Section 68 Evidence Act, 68 Evidence Act says. If a document is required by law to be attested, it shall not be used as evidence until one attesting witness at least has been called for purpose of proving its execution. If there be an attesting witnesses alive and subject to process of the court capable of giving evidence, provided that it shall not be necessary to call an attesting witness in proof of the execution of any document, not being a will which has been registered in accordance with the provisions of Indian Registration Act, unless its execution by person by whom it purposed to have been executed is specifically denied. So this Section 68 differentiate the compulsory examination of witnesses for the documents which were registered and for the which is will was executed. So if you want to prove will, at least one witness should be examined. Then you see what 63 1C says. That is important. Every testator not being soldier employed in actual affair, you execute according to the following rules. That is privileged will, unprivileged. Then they say the will shall be attested by two or more witnesses, each of whom has seen the testator sign or affix his mark to the will, or has been some other person to the will, sign the will in the presence and by directions of the testator, has received from the testator a personal acknowledgement of his signature or mark. All these things are necessary. Then they say Section 71 of the Indian Evidence Act. He says, if the attesting witness denies or does not recollect the execution of the document, the execution may be proved by other evidence. These things are most important. See, the question arises, the 16.3.1 what they says, it's a little bit confusing. You need not confuse because certain witnesses, certain persons who execute the will or attesting or execute any document are exempted from appearing in public. Pardhanasi lady, blind person. For those purposes, Section C is elaborately discussed. So you should clearly understand that the will should be proved by the attesting witnesses who has to say. So, if you want to conduct the cases of challenging the will or want to get validity of will, you must understand the Section 63 of the Indian Succession Act and Section 71 of the Indian Evidence Act and 68 of the Indian Evidence Act, and finally 71 of the Indian Evidence Act. These things are most important. Kindly go through the judgment, very short, not that much of multiple pages. This is AIR 2023, Supreme Court 4787, Dhanarjam died versus Shiva Singh. Okay, understand? Best wishes.